A healthcare directive is a very important document for you to have. Everybody needs it, regardless of the value of their estate. The healthcare directive or healthcare power of attorney serves two purposes. The first purpose is it allows you to designate an agent to act on your behalf when you become incapacitated. If you don't have a healthcare power of attorney in place, there's nobody that has the legal authority to take care of you. So in that situation, a guardian would have to be appointed by a court to manage your health and welfare. And that's an expensive court proceeding that could easily be avoided by having that healthcare power of attorney in place. The second component of that healthcare directive or healthcare power of attorney is what we call a living will. A living will is a document that you provide instructions on how you want the doctors to treat you at the end of your life. Most people don't want to be kept alive indefinitely by machines or any other artificial means if the doctors make a determination that they're brain dead and there's no hope for them to come out of the coma. So they don't want machines keeping them alive. And that living will tells the doctors to stop that medical treatment and let you pass naturally in as little pain as possible. A durable power of attorney is a document that you create that designates an agent to make financial decisions for you during your life if you become incapacitated. It's an important document because if you don't have one, then you lose your mental faculties. Now, again, similar to the healthcare power, there's nobody who's legally authorized to act on your behalf. So, in that situation, a conservator needs to be appointed by a court to oversee your financial decision making. And conservatorships are very expensive and timely, and again, can easily be avoided with a financial power of attorney. The other reason why you don't want a conservatorship is because anytime that potential conservator needs to make a decision for you or spend money on your behalf, they have to ask for court permission. So, this again can easily be avoided by creating a durable power of attorney, whereby you get to choose who makes those decisions for you if you become incapacitated. Another thing to consider too, in addition to the durable power of attorney, is creating a living trust or a revocable trust, because that trust also gives you the ability to put assets into it and allow your successor trustee to use your trust assets to take care of you. And the reason why I say this is important is because with durable powers of attorney, they can be difficult to explain to a third party and allow that third party to uh, accept it. For example, if you take a durable power of attorney into a bank and that durable power of attorney was signed 10 years ago, the bank may not honor it because of its age. So if your agent needs to get money out of your account to pay expenses, they could be having to deal with a difficult situation now and trying to get the bank to honor that old power of attorney. Whereas if you had created a trust, the bank would simply allow your successor trustee to go in and access that account regardless of the age of the trust. I don't know why that is, but that's just a fact of life, and that's why a trust can be used to supplement some of the powers that are given to an agent in a durable power of attorney. A beneficiary designation is a designation on file with a financial institution, a IRA custodian, 401k custodian, life insurance company that provides what happens when the owner of that account dies. So if a beneficiary designation is completed, let's say you have a bank account and you've designated your children as the beneficiaries of that account. When you die, the proceeds of that account will transfer directly to those beneficiaries without having to go through probate. Now, in the context of estate planning, if you have a trust, then you can designate your trust as the beneficiary. And that way, when you die, the value of that account will transfer directly into your trust without having to go through probate. But again, if you do have a trust, the beneficiary designation form isn't as important with bank accounts because you want those bank accounts to be owned directly by your trust. That way, if you become incapacitated, the successor trustee can manage those accounts. Now, for things like life insurance policies, you would want your trust as the designated beneficiary because that way, when you die, the value of that life insurance account would be paid directly to your trust, where it would then be managed by your trustee for the benefit of your beneficiaries. So it's important to consult with any type of estate planning attorney on how those beneficiary designation forms should be completed because it does vary depending on the type of asset or account. One thing a lot of people don't think about is online accounts and what happens to those online accounts when you die. How does your family get access to those accounts? And, it may seem like a minor issue, but it's very important because you may have things like photographs on your iPhone that people want to have access to after you die because, those are important memories that should be preserved over time. And if you don't create a list or make your family members aware of what online accounts you have and what your ID and passwords are, then you risk those accounts being shut down forever. Now, I was involved in a case where a person could not get access to a Gmail account despite court signing an order requiring Google to turn over access to that account. And it caused a lot of unnecessary time and expense in a probate fighting with Google, a very powerful corporation on a very small estate, just to have them turn over access to some emails. So it's very important that your family know where you have your accounts, what your passwords are, but at the same time, it's also important to safeguard that information because you don't want it to get into bad person's hands where they can access your information and do all sorts of damage. So there's a balancing act between the two. A second component recently that's come up is crypto. What do I do with my crypto, and how do I make family members aware of it who may not have any knowledge on how crypto works at all? So depending on the type of cryptocurrency and how you hold it, for example, if it's at an exchange like Coinbase, the exchanges still have not, uh, for the most part, caught up with beneficiary designations and allowing a beneficiary to be listed on the account to avoid probate and those types of issues. So your estate planning documents should be drafted properly to give your successor trustee or whoever the person is the authority to access those accounts on your behalf if something should happen to you. Now, the other potential type of crypto is, a crypto wallet that's a physical item. That's the equivalent of cash. If your family member doesn't know that you have that type of crypto, then they're going to lose that value. So it's important in the context of estate planning to make a list of this information, your online accounts, your crypto, and all your other assets, including where you bank, where you have investment accounts, because if you don't have detailed information and inventory, then there's a possibility that your family member may miss a valuable asset that they'd be entitled to. There's a lot involved in estate planning that people may not necessarily think about. So it's important that you call us so we can explain and go over all the important aspects of your estate plan so that nothing gets missed and your plan gets carried out effectively after you die. So feel free to give me a call with any questions you have, and I'm happy to meet with you. We don't charge for an initial consultation and get your questions answered.